So the force majeure part would apply, which says if there's an act of God, such as a pandemic, and it makes it so that the association is unable to fulfill those obligations, then they may be excused from those. The tough part is that with associations, they're really never going to be the vendor. They're going to be hiring the vendor. So really the obligation on behalf of the association is quite limited, usually to pay the vendor. I mean, there are other ones that go along with it, but usually it's payment. So if you stop payment, then the vendor is probably going to have a real problem with that. If in fact the reason why payment is stopped is because you're no longer letting the people do the work, and the payment according to the terms of the contract are to be made after a certain set of guidelines are met when it comes to the contracting. So in other words, if you're having roofs redone, if the demolition of the roofs is one stage and then building 25%, the contractor gets another payment. If the contractor can't work, is the association still obligated to pay? Probably not. I mean, there's an argument they could still pay even if they don't allow contractors on. But if they can be excused from that, then it leads to the question that you asked, which is, can an association say, well, we can't let the contractors in there? Well, I can tell you one thing. If the association is banning contractors from members, so in other words, condominium or HOA members want to have contractors in the association to do work on their house for non-common area items, and the association says, no, we're banning those, but then they let their own contractors on, there might be a real problem with that, because what's good for the goose should be what's good for the gander. Unless they can make a distinction between the work for members only or cosmetic and the work for the association is protect the health and welfare of the members of the association. So again, it's going to come down to a factual scenario. It's going to come down to how judges treat this and arbitrators treat it. But if they're keeping other contractors from members out, then they certainly should keep their own contractors out unless there's some big exemption there, difference between the members' contractors, and then they may not have to pay as they kind of go along for the contract.